Hello. Apologize for the delay. We were just getting this set up to go. Welcome to our Facebook Live about Georgia divorce law. My name is Sarah Austin. I am a senior attorney in Atlanta Legal Aid's DeKalb County office. I've been with Legal Aid for about 10 years. I mostly practice in family law. So I represent people in divorces, legitimations, custody disputes, and protection from family violence. First, I'd like to give you some general information about Georgia Legal Aid or about Atlanta Legal Aid before we move on to speaking about Georgia divorce law. We work here in the metro Atlanta area in 5 counties: DeKalb, Fulton, Gwinnett, Cobb, and Clayton. If you are in the state of Georgia, but outside those 5 counties, there is a program called Georgia Legal Services Program that serves the rest of the state. We have 5 local offices and also have a number of special programs that serve specific populations or needs. We only do civil practice. We do not do any sort of criminal representation. And we provide direct representation to people throughout their legal cases, as well as giving advice, referrals, staffing clinics and other resources around the metro area, and other ways that we assist people that are not full-on representation. To qualify for our services, you have to live or have a case that has or will be filed in one of those 5 counties, and qualify based on income, which varies a little bit depending on which program or project you're applying to. If you're interested in applying for our services, Sally, our host, is going to put information in the chat about our phone numbers and our website URL, which is atlantalegalaid.org. So that website has all the information. Couple of quick disclaimers before we get started. I am an attorney barred only in Georgia, so this information is specific to Georgia law only. It is relevant throughout the state. There's some changes, some differences in local practice, but the law is the same throughout the state. This is a general presentation. It's not specific to the facts of your case. This is not forming a lawyer-client relationship between me and you or Atlanta Legal Aid and you. If you want specific legal advice about a situation, you should seek advice from an attorney. So that brings us to talking about the meat of the presentation here: Georgia divorce law and practice. First, some definitions. We all think we know what a divorce is, but I want to talk about what a divorce does and who is eligible to seek one. If you are legally married, you can get a divorce. So that's one of the primary reasons to be legally married. It gives you protections through the divorce process. You can have been married in or out of Georgia, in or out of the United States, as long as you were legally married by the standards of wherever you were. People often ask us about common law marriage, which exists to varying extents in lots of states. In Georgia, common law marriage ended in 1997. So if you had met the standards for a common law marriage prior to 1997, you could get a divorce now based on that common law marriage. This is very dependent on the facts of your marriage, so you would want to speak to an attorney if you think you may qualify for that. This also includes people who were married elsewhere legally and whose marriages in Georgia were legitimated by the Obergefell case in the Supreme Court. So for instance, if you were married in another state where same-sex marriage was legal at the time, it was not in Georgia, it was then made binding in Georgia by that case, you are eligible to get divorced, which is, again, one of the major benefits of marriage equality. So again, if you're not sure if you are able to divorce, speak to a lawyer. People sometimes contact us seeking annulment. I think in many cases, they're not sure what it means. It just sounds very serious, like fancy divorce. Annulment is very rare. Annulment means that the court is finding that your marriage is legally void and did not legally exist to begin with, not just that it's ending. So there are limited grounds on which you can seek an annulment. The one that disqualifies many people is that if you have any children as a result of the marriage, you cannot seek an annulment, even if you meet the other grounds. You do have to get a divorce. The other grounds factors, if you lacked capacity to get married because of age or other incapacity, if you and your spouse are too closely related to have been married under Georgia law, or fraud. And this can take a number of forms. Fraud, generally, it's not just, oh, I thought he was a nice guy and he wasn't, but more specific kinds of fraud. So in most cases, a divorce is the proper option for ending a marriage. What can a divorce do for you? It legally ends your marriage. It ends any obligation that you and your spouse have toward each other as partners and spouses, although you may end up with other obligations under a divorce order. You can remarry. You can change your name. Often people will choose to revert back to a prior name, and it's much easier to do a name change at the time of a divorce than any other time, or when marriage and divorce are the two easiest times to get a name change. So we always recommend that if people think they might want to go back to a prior name, they do that as part of a divorce. So those are the things that you will get as part of a divorce, basically automatically. No one has to agree to a divorce for it to happen. If one person in a marriage doesn't want to be married anymore, the law will not make them. So people come to us saying, I can't get my spouse to sign the papers. I can't get a divorce. It's like, well, you can get a divorce. There are a lot of other things that have to be decided as part of a divorce, and that's where things get kind of hairy. Generally speaking, those are things that you can either settle amongst yourselves with your spouse, or you can ask the court to decide them. So we're going to talk about several of those areas in turn. The first one I'd like to talk about is the division of property and debt. Now, when it comes to property, Georgia is not what people call a community property state, where there's a strict rule about how property is divided between the two people evenly. It's an equitable division state, and equitable means fair, but not necessarily even. Is the quickest way to explain it. The court's going to be looking at what is most fair to both parties based on a number of factors in how they divide things. So first, what is marital property? The short answer is that anything that you and your spouse acquired under either of your names during the marriage counts as marital property. Now, in some cases, you can have a thing like a house that is partially premarital and partially marital. For instance, if one spouse brought a home into the marriage, but then you paid the mortgage together and you had equity in the home that was accrued during the marriage, part of that house and its value may be considered premarital and part may be considered marital. Money, investments, pensions, retirement plans, vehicles, furniture, any other valuables, basically everything up to, your very personal property like clothing and such that typically is not divided in divorce. And there are some specific exclusions. As I alluded to, in property that you brought into the marriage, in many cases is considered non-marital. Gifts that were made to only one of the spouses can be considered non-marital, and inheritances of only one of the spouses may be considered non-marital. In both those situations, those would be things that had to be kept separate from your marital assets. If you've the term is commingling. If you've taken your inheritance, for instance, and deposited in your marital checking account and combined it with your general operating funds for the household, it stops being a separate asset. So that's something to keep in mind if you have certain kinds of assets and you're considering a divorce. How can property be divided equitably? So the factors that the court may look into in deciding, how things can be divided may include, where they came from, who purchased them and why, who were they used by. For things like money that may not have like specific connections or entanglements, they're looking at, what is most fair to everybody in the big picture. And that can interplay with other things like spousal support, child custody, and whatnot. For instance, it may be a compelling reason for one person to stay in the marital house might be if they have custody of the children, primary custody of the children, so the kids get to stay in the house. So there are a lot of factors that get entered into deciding where property goes and how it is divided. It can be straight down the middle. It can be buyouts where one person, especially for things like houses where both people can't keep it, you can't cut it in half. So one person may buy out the other person's interest. You can balance them by saying one person gets this asset, one person gets this other asset that's roughly equivalent. And things can be sold and the proceeds can be split. This can either be because both parties agree it's the right thing to do, or particularly for real estate, often the court will order that something is sold because they determine that that's the fairest way to split the equity. That brings us to debts. And if I will say, and this will come up over and over again through this presentation, in all of these things, you have the option to try to reach agreement with your spouse during a divorce about how something is going to be handled or divided. And in most cases, the court will sign off on that and make it their order. If you do not agree, then we get into what will the court do and how will they choose to divide these things. So when it comes to debts, again, it's a question of equitable division, not necessarily 50-50 equal, but what is fair. They'll look to what are the debts for, who incurred them, did the other person know about the debt or agree to the debt or, strongly object to the debt. It can be any kind of debts, mortgages, medical bills, credit cards, student loans. Certainly you can argue that some debts shouldn't be considered marital and that one of you should bear sole responsibility for that debt. And the court can consider that. But the presumption is that if a debt arose during the marriage, regardless of whose name it is in, it is subject to division. And that division might look like the court saying, you bear all responsibility for this, your spouse doesn't, but that is one way to divide them. So as a practical matter, and as a matter of protecting your credit, if you have a debt that's held in one person's name, after a divorce, it will generally remain held in that person's name. Now, if the court finds that the other person bears some financial responsibility for that debt, they may order them to pay the other spouse some portion of the money, and the spouse can enforce that through contempt. But the creditor, Visa or whoever, is not going to come after your spouse if they fail to pay you for their portion of the debt. So in the end, you remain on the hook for things that are in your name. It's your credit at risk. And, for this reason, often people will choose to largely keep the things that are in their own name and have their spouse keep things that are in their name to the extent that that's doable and fair. There are some exceptions. Some things like home mortgages can be refinanced to add or remove parties from the documents. But in many cases, if it's in your name, it's in your name. And the creditor is not going to come after your spouse for it after the divorce. That brings me to talking about another big money issue, which is spousal support or alimony. People use the terms kind of interchangeably. So spousal support is not a given. Whether it is ordered in a case and why and how it is ordered, how much it is ordered and under what terms, is very specific to the facts of the marriage. The courts will, if the court is deciding about this, they will look to how long people were married, the roles of the people in the marriage, any disparity in their earnings and their earning ability, and the ability both have to return to work or build up a career. So sort of the classic scenario for spousal support is when you have one partner who had a very big job, maybe that required long hours or travel or whatnot, and the other person was more of a at-home parent or worked much less to kind of keep things on the home front. And so you have a big disparity in earning. If you are the person who's seeking alimony, then your argument is that you're being able to be available for that, being at home and supporting the household and maybe supporting their career in other ways, enabled them to have this earning power at the expense of your earning power. And so you would be seeking spousal support to kind of keep yourself in that, at a standard of living that you've become accustomed to or close to it for some period of time. Now, a lot of this is going to depend on everybody's work history and qualifications and so on. If you have two people who are both licensed doctors and one of them chooses to have a much lower stress, lower paying job so that the other one can work really long hours, well, presumably they could then ramp back up at some point and, work longer hours. And so it may not be a long-term need. If one person has a high paying career and the other person doesn't have qualifications for a high paying career immediately, they might get alimony in sort of the short term called rehabilitative alimony, where the idea is that you receive this for a shorter time of maybe a few years while you are developing job skills and getting back in the working world and building up your earning potential. And there can be longer term or permanent alimony. This is not favored in Georgia, permanent alimony. It's most common in cases where one or both of the spouses are on the older side or permanently disabled. They're not likely to build up to a higher earning ability in the foreseeable future. So that's where you might see permanent alimony come into play. In many cases, alimony would end if a person were to remarry or under certain other conditions. So if that's something you're considering, you would want to speak to an attorney about your case. Spousal support is separate from child support. In many marriages where there are minor children, you might have both, but they are separate pools of money essentially that are ordered separately. So that can be a point of negotiation if you're trying to settle a case, trying to reach an agreement with your spouse that, what money is allocated as what kind of support, because they may be enforceable in different ways. They may end at different times. So that's something to consider. You can also divide assets in lieu of spousal support. For instance, saying that instead of getting monthly spousal support payments for however long, you'll receive this investment or this pile of money. If you have assets that can be divided, that can be a cleaner way to do it so that you don't have this ongoing obligation. Someone just gets something up front that sort of allocates in to take care of that need. So that brings me to talking about children, which is a big part of divorce for many people, the custody and support of the children of the marriage. So first of all, who are we talking about here? Generally, we're talking about children under age 18 and children that are of the marriage. They can have been born before the marriage as long as the two people getting divorced are the parents of that child. This includes adoptive children, assuming both people adopted them and are their legal parent. It does not include stepchildren unless the non-biological parent completed a step-parent adoption, at which point they are that kid's legal parent as well. There are some special notes here for families that came about in a more non-traditional way. If you have one person who's the biological parent and the other parent did a second parent adoption, which is essentially like a step-parent adoption, they become a full legal parent. There are also scenarios where two people chose to have a child or children together, but one of them is the biological parent and the other one, for whatever reason, has not done a second parent adoption. Georgia law provides for something called equitable caregiver status, where someone can seek the legal status of a parent, essentially, in a situation where they have taken on that responsibility, intending for it to be permanent. Second parent situations in which someone has not adopted their child legally is one scenario that often comes about. So that's, a special situation you would want to speak to counsel about, but you can account for that if there is a child who is effectively of the marriage, but who is not legally your legal child. So we are talking about children only up to age 18. People do often reach divorce settlement agreements that have to do with the care and support of kids who are disabled adults and dependent on a parent. Georgia law doesn't provide for the court dividing custody and support of children past age 18. So that's something that's by agreement only, essentially. The court will always want there to be a court order about child custody and child support that goes into the specifics of what that looks like. Now, this may or may not end up being what you do day to day. Ideally, if the parents have a pretty amicable relationship, they're able to make minor changes as they go along. And the court's fine with that. But they're not going to allow you to go into your divorce saying, oh, we're just going to figure it out, because they want to have a fallback plan and minimize people ending up back in court. So they're going to want you to have what is called a parenting plan. And it is a long document that it becomes incorporated into your divorce order and becomes part of the court's order. And it goes through all the specifics that have to do with child custody and the care of your children. So when we talk about child custody, there are two kinds. There's physical custody and legal custody. Physical custody has to do with where the children primarily live. There are two main models that we see most often. There's primary custody, where one parent has the children more of the time and they visit with the other parent. And there's 50-50 custody, where the children spend an equal amount of time with both parents. In either case, each parent is going to be entitled to specific time. And the court, again, is not going to allow you to kind of make that up as you go along or say, oh, we'll figure it out each week where they should go when. There has to be an official schedule, even if for practical purposes, you really do just figure it out as you go along. A lot of times people come to us saying, oh, I want sole custody, or my ex is asking for sole custody. This is a point of confusion. True sole custody is pretty rare. Most of the time when people come to us saying that's what they want is for the child to live with them. And in many cases, that's what would be considered primary custody, where the person is with, that child lives with them more of the time. And they're sort of the primary day-to-day parent, but the other parent spends time with the children or has visitation and has input on major decisions. True sole custody would be where one parent has 100% of the time 100% of the decision-making power. And it is pretty rare, and it is reserved for pretty extreme situations unless the other parent just agrees to it. So that's typically in situations of abuse or abandonment where it's truly not in the child's best interest for that person to have any involvement. So legal custody has to do with who makes major decisions on children's behalf, things like where they go to school and whether they're raised in any religious faith, medical care, stuff like that, and who has access to their records and medical care in school. So the default situation is that parents have joint legal custody. Most judges will order that in the absence of any reason not to. And that just means that both parents do have access to those records and the right to, speak to schools and doctors and so on about their children. One person typically has to have tie-breaking vote in those major decisions because, ideally the court does want parents to consult about these decisions. And what joint legal custody implies is that if you have to make a major decision for your child, you will, consider the input of the other parent, you'll solicit the input of the other parent and make a good faith effort to try to reach an agreement. But they always want there to be some sort of tiebreaker provision in there because, inevitably some people are not able to agree. And so usually the tie-breaking provision is that one parent has that tie-breaking vote, whether that's the parent with primary custody. Sometimes the parents will split it up and say, oh, you get final say on education and I get final say on medical care. Other times, this is more uncommon, but sometimes people will put a different kind of tiebreaker provision in, such as we will defer to the advice of the specific pediatrician or whatever it might be. But the most common is that one of the parents has the tie-breaking vote in these major decision-making areas. As I mentioned, you'll have something called a parenting plan that lays out all these details about how you handle decision-making. It also goes into detail about things like how summer vacations and holidays are divided, how you will communicate with each other about caring for the children, who will provide what things for the children, who will transport them for visitation, all of that. And it becomes part of the final order. Generally speaking, if the parents work together to draft a parenting plan, either on their own or with the help of a mediator, it's going to be more specific and more tailored to the needs of their family than if a judge drafts it or judge staff drafts it. Because a judge and their staff are generally going to have some kind of default one-size-fits-all ideas in mind. They can't go through every need of every family they see. And so they're going to do something that broadly will work for many families. So in most cases, you are going to be able to end up with a parenting plan that's more specific to your child and their needs if you and your spouse are able to work together on that, possibly with the help of attorneys and a mediator. So that brings us to, if you're not able to agree on child custody, if both people want primary custody, it's contested, or if there are disputes about what visitation will look like, or any number of things that have to do with child custody, the court follows the standard of what is in the best interest of that child. Now, Georgia law lists a number of factors that the court is supposed to consider in deciding best interest. Some big ones that come up a lot are which parent if there's been a primary caregiver in the household, who's been more involved in the children's care and education and so on. They want to keep continuity of care. So if the children are very settled in one situation, that might be a reason to continue that situation and be less disruptive for them. They generally want to keep siblings together. So unless there's a really good reason to, most of the time they will have all children remain in one custody schedule and not split them up. They look to issues of safety like domestic violence, substance use by either of the parents, things like that. In some situations, they will consider the input of the children themselves. Georgia law provides that children who are over age 14 can make what's called an election, where they tell the court which parent they would prefer to live with. Now, as a practical matter, judges vary pretty widely in how they consider this. And almost universally, they're not going to order what the child wants if it's clearly not in their best interest, if the child is unsafe with the parent they chose to live with or whatnot. It also can create a lot of stress and trauma for the child themselves. So in many cases, it makes sense not to go that route, but it is a possibility. There's also a way to consider the children's input and also just to consider the children's needs is by the appointment of a guardian ad litem. So a guardian ad litem is a person appointed by the court. Most of them are also attorneys, but some, you don't have to be an attorney to be a guardian ad litem. And their role is to investigate the case, get to know the parents and the children and the situation, and make a formal report to the court about what they believe is in the best interest of the children as far as the custody situation goes. Now, that means that the guardian ad litem's obligation is to the children and to the court. It's not to either parent or to their attorneys. So they're more neutral. They're not coming into it with predisposed ideas about, what is going to be best for the kids, although of course they're people and each person has their own biases. The benefit of a guardian ad litem is that they can investigate a situation much more fully than any judge has the ability or the time to do in every case. So they have the ability to speak to children's teachers and doctors and family members and really get a full picture of what's going on. They are able to speak to the children in a less formal, more comfortable way so that they get a sense of what the child wants and prefers without a child having to testify for or against either of their parents. It's more a comfortable and formal situation. So the child doesn't get put in the middle of that. And they can look to the reasons for what the child may want. If a child says, oh, I want to live with mom because she doesn't make me do homework or go to school, the guardian's probably going to say, yes, what Jimmy wants is this, but what is in Jimmy's best interest might not be that. So the guardian ad litem can play a major role in contested custody situations. The judge can choose to completely ignore what the guardian recommends, but in most cases, they consider it pretty strongly. A guardian ad litem can be appointed either because one or both of the parents have requested them, or the judge can say, clearly a guardian ad litem is needed here and order that one be appointed. Depending on the circumstances of the parties, sometimes that can be handled at no or low cost through the courts or through other agencies. And sometimes the parties pay for the guardian ad litem just as they would pay for their attorneys. Custody changes. Once you have a custody order in place, it is the order of the court. And in order for it to change, there has to be a significant change of circumstances. This can be things that, like, just the children getting older and their needs changing. It can also be maybe one person moving, maybe some significant change in the children's health or school situations, anything that makes it, there's something new that has arisen that means that a change of custody is appropriate. So it's not as though you can just pop back into court a month after you get your original divorce order and say, oops, I changed my mind. I actually think this other thing is better. So if you're trying to reach an agreement on a custody situation, or if you're having hearings about a custody situation, you want to avoid ending up in a situation and just assuming it's going to change easily or quickly, because that's usually not the case. I want to speak quickly about informal and formal modifications to a custody order. Like I mentioned, the courts do want parents to co-parent amicably. If you share custody with your ex and you have a good relationship and you are able to work things out on a day-to-day basis, like, oh, I have an appointment, can you get so-and-so this day instead of that day? That's great. That's great. And the court smiles on that. If you do end up back in court, though, they're generally going to enforce the order as it's written. So if you see a situation arising where a more formal change to the order might be necessary, it's in your best interest to document everything, to do your communication with your co-parent in writing, especially if you have a contentious relationship with them. And that will be helpful if eventually you do end up back in court trying to seek a modification. Sometimes we see situations where people have done something other than what the order says for a very long time. And it's like, oh, the order says I get visitation every other weekend, but really I have the child half the time. If you have documentation of that over a period of months or years, then that's going to be a pretty compelling reason that the custody order should be changed. So those informal modifications can be great. They do only take you so far, and you want to document what you're doing in case the need comes to make a formal modification. I'm going to drink some water and now talk more about child support. So custody tends to lead into support in that if you have one parent who has primary custody and has the children more than half the time, the other parent is usually going to be ordered to pay some child support. Even in 50-50 custody situations where the parents spend equal time with the children, there can be an order of support if there's a significant gap in the earning ability or the earnings of the two parents, because the courts want children to have a pretty consistent standard of living between the two households. And, if, for instance, one parent has to pay to stay in a much more expensive area so they can be close to their other parent, you might end up with support paid even in that situation. So the court uses a formula that's used statewide in Georgia to come up with what's called the presumptive amount of child support. And that's a formula. They plug in both people's income. They plug in any ongoing monthly expenses that either person pays for things like childcare or health insurance, stuff like that. This does not account for just day-to-day expenses like food and clothing, but anything that you pay on an ongoing basis. And then you can get deviations from that statutory formula for things like if one parent has a extremely low or extremely high income, or if either parent has other children besides the children of the marriage that they're supporting. Those are things that can be factored in. Once you end up with that presumptive amount from the formula, the parties can argue for that to be moved up or down, but the presumptive amount is where the judge is going to start in terms of deciding what support to order, and often it's where they're going to end. So, the formula has been calculated with all these things in mind, all of the sort of exceptions that people might come up with. So you have to have a pretty good reason to ask the court to deviate from it. That's assuming you're asking the court to order a deviation, though. If the parents agree on something, whether it's for a parent to pay more or less child support, or for it to be offset in some other way, like, oh, I'll pay for daycare, but I'll pay less of out-of-pocket child support. Usually the court will honor those kinds of agreements as long as they don't put the children in a really untenable situation. Again, they always encourage parents to settle these disputes among themselves, and so they will sign off on it generally as long as it's a reasonable agreement. Now, when the court is calculating child support, I say they're going to put in both parties' income. That's not always, they don't always use the amount of income that you actually make if there is evidence that that's not really reflective of your earning ability. Income can be imputed, which means the court will assume you have the ability to earn a particular income if they have, strong reason to believe that that's your actual earning ability. So it's not uncommon for people to quit a job or downshift in their job when a divorce is imminent or pending, so that their income looks lower on paper. If that happens, and then the other side goes into court and says, but look, judge, 6 months ago, they were earning this much, and there's no obvious reason they can't earn that much now, it's likely the court will impute their income at the amount they were recently earning or that they're capable of earning. So that's one thing to consider. It's pretty hard to hide your income or downplay your income at the last minute. People think that the judge isn't going to notice that you left your job 4 months ago. That's generally incorrect. It does get more complicated in situations where people are self-employed, paid under the table. Those are situations in which it can be really helpful to have a strong attorney advocate on your side who can help dig out income that the other side may be trying to hide. But in the best case scenario where someone is a W-2 employee and you just plug that number from their tax forms into the formula, and that's that. And once support is ordered, it can be enforced through what's called an income deduction order. This can be entered as part of the divorce, just saying that child support will be deducted from their paycheck so that it happens automatically. Sometimes the court orders that from the get-go. Sometimes they order that it will go into effect if the person gets behind on support by a certain amount. And sometimes they don't order it at all if everyone seems confident that it isn't necessary. And in many cases, it's not, if someone is acting in good faith and wants to support their children. So now I'm going to talk about some procedural stuff, things like how and where you would file a divorce, if that's something you're considering. So there are layers of this. The first layer is which state has jurisdiction and which state should you be filing divorce in. You may have a choice about which state to file divorce in if you and your spouse maybe live in different states. And it gets more complicated when there are kids in the mix, because you may have 2 or more states in which you could file a divorce. For instance, if I'm married but separated and my spouse has moved to New York, I could file for a divorce here. I could also file for a divorce in New York. But if we have children, I have to look to which state has jurisdiction over custody and support of those children. Now, there is an interstate compact called the Uniform Child Custody Jurisdiction and Enforcement Act. We call it the UCCJEA for short. And the UCCJEA basically says that there's going to be one state that is called the home state for any child. And that is the state that has the right to decide their custody. Now, there's always going to be exceptions. There can be emergency exceptions, like if someone left a state to flee violence or something like that. For the most part, though, the rule is going to be that if a child has lived in a particular state for the last 6 months with either their parent or someone acting in the role of a parent, then that state has jurisdiction over their custody. If they haven't lived anywhere, if they've lived somewhere for less than 6 months, it's going to be wherever they most recently lived for more than 6 months. And so you may have a situation where another state has jurisdiction to get you divorced, but it's not going to account for your children. And in most cases, people do want to deal with all the things that are part of the divorce all at once. And so it makes sense to file in the place that also has jurisdiction over custody of the kids. Once you've established, presumably, that you want to file in Georgia, you have to figure out which county you need to file in. Again, there's a general rule and there's a bunch of exceptions. The general rule is that you're going to file a divorce in the county where the respondent lives, the person you're filing against. If they have moved to that county in the last 6 months and they previously lived in another county as, that was your marital county that you lived in together, you can still file in that county where you had your shared residence. If your spouse can't be found in Georgia, even if you know they're somewhere around Georgia, but you don't know exactly where they are, then in some cases you can file, if you have truly no idea where they are, you could file in your county. We'll also talk about filing for service by publication, which is the option if you have no idea where someone is, in which case you may need to know the last known county they lived in. Another important thing to know about county venue is that it can be waived by either party. So for instance, if you really want to file in the county where you live and you know that the county where your spouse lives is somewhere else, if you file it in your county, they would need to raise that issue in their answer and say, hey, wait a minute, I live in this other county. I need to have this case heard here. Generally speaking, if they were to do that, the court would say, yeah, they're right. Let's hear it in this other case. But if they don't raise it, then they have waived the right to ask that it be held in their county. And in many cases, if people are on good terms, they might strategically choose to file in a particular county for reasons like getting access to mediation, things like that. So, you may have some choice in where you file. You may have that may be something to speak with your spouse about if you're on good terms. And even if you're not on good terms, if you file in your county and they do not object, then it can't proceed in your county. They just have the right to object if they don't live there. So when you are filing, there's some steps to think through. The first thing is that there is a cost to filing any court case. All counties have their own filing fees for filing a divorce and all the necessary paperwork for that. All Georgia counties also offer what's called a poverty affidavit, which is a kind of waiver you can apply for, asking the court to let you file for free if you are low income. Counties have different procedures for how they handle this, but they all have some version of it. So if you are low income, that is something you should look into when you apply or when you get your filing documents together, ask in that county. Across Georgia, in any domestic case, which is any family law case, there is a domestic relations standing order that goes into effect at the time the case is filed. And this is true whether it's a divorce, a custody case, any other case that has to do with family law. And the standing order, among other things, it provides that neither of you is going to mess with your marital assets. That's the technical term. Emptying out accounts, transferring stuff, selling stuff, other than what's beyond the ordinary course of business. So yes, you can access your checking account to buy groceries. No, you can't empty out your checking account after the standing order goes into effect. The standing order also prevents either parent from taking the children out of the state. As a practical matter, if you and your co-parent agree, like, oh, we're going to Florida for the weekend, that's going to be fine. But the intention is that you are, it's preventing either party from leaving the state without the other person's knowledge or fleeing the state to avoid the divorce. So if there are things, you want to strategically do before the standing order goes into effect, that is something you would want to speak to an attorney about, make sure that this is the right time to file. Sometimes people will talk to us who have already left the state and are considering filing in Georgia. And we have to tell them, well, if you have children and you're already out of state, you may want to wait until you can file there because you're already going to be in violation of the standing order. So just something to consider. You have to think about how you are going to serve your spouse with notice of the divorce. If they can be located, you will need to have them formally served by personal service, someone bringing it to them. The alternative is that if they will agree to receive the paperwork from you and sign a piece of paper called an acknowledgement of service, that basically just says, yes, I've received this paperwork. You don't need to officially serve me using the sheriff. And it can save everyone some stress of having the sheriff come to their home and get served, if that's an option. Again, if you're on amicable enough terms that they'll agree to that. They're not necessarily agreeing to any of what you want in the divorce. They're just agreeing, yes, I've received this paperwork. You can also, if someone truly cannot be located, you can serve them by publication. This is where you ask the county where you're filing for divorce to let you file a notice in the local legal newspaper. And the notices just say, John Doe is filing for a divorce against Jane Doe, case number whatever. And it counts as legal notice so that Jane Doe is formally on notice that this is happening. But it's only available in a situation where you can show the court what you've done to try to find your spouse. So you would need to fill out an affidavit saying what you had done, who you'd contacted, where you'd searched to try to locate them before the court will order service by publication. You have to show that you've made that good faith effort to track them down. In an amicable situation where everyone's either more or less on the same page or can get on the same page through things like mediation, you can actually get everything settled and have a settlement agreement and everything signed and file it basically as a done deal and ask the court, say, hey, we want a divorce. Here's all the agreements we reached. We would like you to sign off on them. And then the court will either set a brief final hearing where you both say, yep, we agree to this. Or in cases where everything's truly all settled, in some cases, you can get what's called a judgment on the pleadings, where the court says, yeah, we reviewed this, everything looks good, you're divorced, and you don't even have to appear in court. So in the best case scenario, where things are either very amicable or very uncomplicated, you can file a complete divorce with a settlement agreement and get it done potentially in a matter of weeks. Whereas, the more contested it is, the longer it takes. In cases where you have significant contested child custody and things like that, in some cases it can drag on for years. So I've referred to mediation a few times throughout this presentation. I'll talk a little more about that now. Mediation is an option where you meet with a professional who's trained in dispute resolution and helping people work out these points of disagreement to try to reach an agreement with your spouse about some or all of the issues in your divorce. So it's not all or nothing. You can go to mediation and, for instance, maybe you agree that this person's going to have primary custody, but you don't agree on how much child support's going to be. That's fine because it's one less thing for the court to decide. And generally speaking, the judges are happier to have fewer decisions to make about your life. And it generally will make the parties happier to have more control and input over what they're going to be living with for the future. So anything that you can reach some settlement on is good. Many counties have some kind of free or lower cost mediation available. For instance, in DeKalb County, where I practice, in any family law situation, you're entitled to up to 2 hours of free mediation. So that might be a strategic reason. If you had 2 or more counties you could file in, that might be a reason to file in a county, is if it gives you access to free mediation. If both people are even a little bit reasonable and willing to try to work toward resolution, it's worth trying. It's also often worth trying, frankly, even if you don't expect it to be productive, because many judges like to see that you have tried to settle things, especially in cases where it is available to you at low or no cost. There are also private mediators. And so it's generally a lot less expensive to mediate a divorce than to litigate it. So even if you're not eligible for any free or lower, super low cost options, it can be a great option to hire a mediator for a few hours rather than spending months of your life litigating a case. So people come to us or to any lawyer and say, oh, I'm getting divorced. Do I need a lawyer? So I'm never going to say no, definitely not, because, it can always be to your benefit to have someone who knows the system talking you through it. But there are situations where people handle divorces on their own, pro se, which means unrepresented, without it being much of a problem. If everyone involved is reasonable, if there's no abuse or control issues at play in the divorce, if there aren't systemic barriers to that person or people accessing the courts, like language or literacy issues, and if either there's not very much for them to argue about, or they're able to utilize dispute resolution, use a mediator to sort out the issues that they have to sort out, then you may be able to get a divorce without lawyers being involved pretty easily and have it be fine. It never hurts to consult with a lawyer. And for anyone who's considering a divorce, I think it's worth consulting with a lawyer just to get an honest sense of whether there may be issues you're missing. Many counties have something like a family law clinic. In DeKalb County, it's called the Family Law Information Center. There's a similar one in Fulton County. I know the DeKalb and Fulton ones sometimes do see people from other counties. It's not required that you live in DeKalb County to come to the DeKalb County Family Law Information Center. And those are, low cost options to meet with an attorney who's not necessarily representing you, definitely not representing you in the Flick situation, but they're able to review the situation, maybe point out any areas you might have missed, and give you an honest assessment of, do you really need an attorney going forward? Is there something here you need further assistance with? And then you could go find an attorney after that point. That's a good way to get sort of a low cost introductory session. There are also, most private attorneys will do low cost consultations for a first meeting. And ideally, a good attorney is not going to try to upsell you. They'll tell you honestly what degree of help you need. So it may be worth meeting with one or a few to get a sense of what's out there. Are you really missing any issues here? Or is this truly a simple issue that you can move forward on your own and doing your divorce? There are also attorneys who work collaboratively to help people resolve their divorce. That can be a good option in situations where both parties are, again, pretty reasonable and trying to work collaboratively toward resolution. There are attorneys at almost every price point. There are attorneys who work on flat fees where you pay a set amount up front and that's what it costs. There are attorneys where you pay a big retainer up front. Lots of different options. So I would recommend the Atlanta Bar Association has a family law referral service. If you're looking for a family law attorney, they may be able to send you in that direction. There are also family law attorneys who specialize in any sort of unusual situation, divorces where one or both parties are in the military, divorces where, you have children who are, maybe not legally one person's child when they're trying to establish parental rights, anything like that. There are going to be attorneys who specialize in it. Finally, I'd like to talk about domestic violence concerns. This is a major reason that people may seek a divorce, and it's a major reason that we end up seeing people at legal aid. In cases where you're trying to get out of an abusive or dangerous situation, the first thing to know is that is a dangerous time. Statistically, when a victim of abuse is trying to get out of an abusive relationship or marriage, that is a time when they're at great risk of the abuser amping up the abuse to try to keep the status quo. So we always recommend that anyone who's considering trying to get out of that situation, speak to someone who's in that domestic violence advocacy world about safety planning. We recommend the Women's Resource Center, which is located here in Decatur, but they advise people around the state. They have a toll-free number that Sally can put in the chat. They can advise people about safety planning and steps they might want to take prior to filing a divorce or prior to their spouse becoming aware of them looking for a divorce, to protect themselves or their children, and put some things in place. Now, one appropriate first step if you are looking to divorce an abusive spouse might be getting a temporary protective order. Temporary protective order is something that the Superior Court in each county has the authority to order if they find that by a preponderance of the evidence, it looks like there has been an act of violence or a threat of violence. So it's a lower standard than a criminal law case. They just have to see that, I think it's more likely than not that this happened. And it doesn't implicate the person who committed the act in a criminal way. It's a civil finding. But in cases where there is, recent or ongoing violence, it can be a good option to get a protective order in place, because that can establish both that the abuser has to stay away from the victim. It can also establish child support, child custody, who has the right to stay in a marital home. It can put those things into place on a short-term basis. Because a divorce can be kind of a long haul. If you file a divorce today, you may not get a hearing for months, and in a dangerous, abusive situation, that's keeping you in ongoing danger. So a TPO could be a way to establish those baseline rules for custody, who stays in the home, and so on. And it's available because of the history of violence. Again, the Women's Resource Center is a great resource for this. If you happen to be in DeKalb County, they are also the agency that assists people in filing for TPOs here in DeKalb County, but in other counties in the state, they would be able to refer you to local agencies, shelters, and other resources that might be available near you for that situation. When it comes to domestic violence, you can seek certain kinds of relief in a divorce that are related to that violence or because of that violence. You can get in a final divorce order, the same kind of language that's in a protective order, saying that your former spouse can't come to your home or your work or contact you for any reason other than, specific things having to do with your children and whatnot. It can put boundaries around that contact and create a basis for contempt if they violate that. In cases where there's been domestic violence and there are children in the relationship, that can be a factor in figuring out what custody and visitation are going to look like. Assuming that the other parent who has been abusive has ongoing contact with the kids, the court may order that custody exchanges take place in a public place, or that they be handled by a third party. They may require supervision in certain situations for visitation. And domestic violence can definitely be a factor in who has primary custody of children. There's plenty of research out there that even when children are not directly abused themselves, being around abuse, being part of a household with domestic violence as part of the situation is an adverse situation for them and has bad impact on them. And so if one parent has documented violence issues, then that can certainly factor into who ends up with primary custody of the children. The court is not going to use domestic violence as a punitive factor in dividing assets and debts, in the same way that they're not going to use other bad behavior like infidelity or drug use or whatever. They're not going to say, therefore you get the house because of this. But they're not looking to financially punish people, but that does become an indirect consideration when they're dividing assets and debts, when there have been things like financial abuse. If one person was prevented from working or barred from knowledge about the financial workings of the household, if one person was really controlling the money, that can be a big factor in sorting out how debts and assets are handled in the divorce. So again, this is a situation where an attorney would be a great help. And I would strongly recommend getting counsel if you are someone trying to get out of an abusive marriage, both because of these added layers in deciding how everything works out with custody and division of debts and assets, but also because, if someone is historically been abusive, they will use the legal process and the divorce as a way to continue abuse and control. And having an attorney creates a layer of distance between you, and that can keep you safer, probably make it much less emotionally stressful and hopefully get you a more just outcome. When we end, I am going to wrap up on some general information about legal aid. But before we move to that, if Sally has any questions from the chats. Okay, someone was asking about if you've incurred debts because of criminal history or credit issue, but the spouse is working and does make money. So that gets into those very specific fact situations of what would happen in a specific divorce. If you have debts that one person incurred without the knowledge or consent of the other person, the starting place is still that they are marital debts that are subject to division, but those are definitely factors the court would consider in who has to take responsibility for those debts moving forward. If you can show the court that you were not aware of this debt, that it was something that your your spouse ran up without your knowledge or consent, that can certainly factor against you having to take responsibility for it in the long term. Criminal history, especially when you have debts that are related to things like domestic violence or crime, if it was really due to one person's wrongdoing, that's a strong factor that would, be in favor of them taking responsibility for it. Again, the presumption from the very beginning is if it happened during the marriage, it's subject to division, but those are all things that would factor into how it is divided. If your spouse is incarcerated or deployed, these are sort of special situations when it comes to jurisdiction and venue. The short answer is that when someone is incarcerated, the venue for their divorce is going to be in the last county where their residence, their legal residence was prior to being incarcerated. So you don't have to file in the county where the jail is if their legal address is still where they were living prior to going to jail. In military divorce, there could be a lot of different factors on where you can file. This may be one of those situations where there's another state that you could file, but that other state may not have jurisdiction over property or custody of your children if your spouse is stationed in another state, but everything else is back here in Georgia. If they're deployed overseas, then you would look to what's considered their home state where they were deployed from, essentially, the state in which they claim legal residency, even if they are now based overseas. But in both those cases, particularly in military divorces, I would recommend speaking to someone with specialty experience in that area, because there are some special factors in dividing military assets, retirement, and so on. For the divorces that legal aid sees, are there income ceilings, domestic violence restrictions, age restrictions, et cetera? So the short answer is yes, and that we don't take every divorce that comes through the door. We just physically could not, because we only have a small group of full-time attorneys, and we get calls about divorces every day. There is an income ceiling just to be eligible for our services to begin with. In cases where there may be a lot of household income, but the person calling us maybe does not have access to that income, or financial abuse is a factor, we do take that into consideration if they do not have the ability to hire an attorney with the money that their spouse controls. Domestic violence is a big factor in the cases we are able to take on for full representation, but it's not the only factor. We do take some cases where there is no domestic violence history, and we unfortunately have to turn away some cases where there is a domestic violence history. But we will advise people on any situation we can, as long as they are eligible for us based on income and location. Age-wise, there's no restriction there. Some of our programs are specifically for different demographics, and one of those is we have the senior legal hotline that's for the entire state. And then we have our senior law project here at Legal Aid, which is specifically for older folks. But there's no minimal or maximum age to contact Legal Aid generally. And if you are eligible for one of those special programs, we will, sift you through to that program and make sure you speak to the right people. Do we have any other questions? Okay, I'm going to give you all some general information. Again, Sally will put the contact information for Legal Aid's main office and our website URL in the chat. You can find tons of information on our website or call us. This video is going to remain available on the Legal Aid Facebook page, so people can revisit it if they want to come back for more information. And we thank you for your time and for your attention. Thanks for coming today. Have a good one.